5 seconds to go. Start. Muslims were not in possession over the suit property, and there is no reliable evidence to indicate that prayers were offered by them from time immemorial, and para. Muslims have not established exclusive and continuous possession over the suit property from 1528 AD, or that they offered prayers in the disputed structure since time immemorial. Stop. On the other hand, the Hindus have established exclusive possession over the inner courtyard and that they were visiting it for offering prayers. Stop. Para. During the course of hearing, Mr. Parasaran, learned senior counsel objected to the maintainability of suit 4 on the ground that the suit could have only been instituted at the behest of a mutawali. Stop. It was urged that the Sunni Central Waqf Board had no locus to institute the proceeding. Stop. There is no merit in the submission. Stop. Section 19(2) of the UP Muslim Waqf Act 1960 specifically empowers the board to adopt measures for the recovery of property and to institute and defend suits relating to waqfs. Stop. Under section 3(2), the board is defined to mean the Sunni Central Waqf Board, or the Shia Central Waqf Board constituted under the Act. Stop. Clearly, therefore, in terms of the statutory power, the Sunni Central Waqf Board has authority to institute legal proceedings. Stop. Para. In the plaint in suit 4, the cause of action for the institution of the proceedings is founded on the events which took place on 23rd December 1949, during the course of which idols were placed inside the mosque by a crowd of Hindus. Stop. The intent of doing so was to destroy, damage and defile the mosque. Stop. Moreover, according to the plaintiffs, this act of entry into the mosque and the placement of idols amounted to a desecration of the mosque. Stop. This clearly emerges from the averments in paragraph 11 of the plaint, para, that the Muslims have been in peaceful possession of the aforesaid mosque and used to recite prayer in it, till 23rd December 1949, when a large crowd of Hindus, with the mischievous intention of destroying, damaging or defiling the said mosque and thereby insulting the Muslim religion and the religious feelings of the Muslims, entered the mosque and desecrated the mosque by placing idols inside the mosque. Stop. The conduct of Hindus amounted to an offence punishable under sections 147, 295 and 448 of the Indian Penal Code. Stop. Para. Linked to the above averment is the statement in paragraph 23, which reads thus, para, that cause of action for the suit against the Hindu public arose on 23rd December 1949 at Ajodhya district, Faizabad, within the jurisdiction of this honorable court, when the Hindus unlawfully and illegally entered the mosque and desecrated the mosque by placing idols in the mosque, thus causing obstruction and interference with the rights of the Muslims in general, of saying prayers and performing other religious ceremonies in the mosque. Stop. The Hindus are also causing obstructions to the Muslims gang in the graveyard, and reciting Fatiha to the dead persons buried therein. Stop.